if you think mandatory condo education for board members was controversial, you haven't heard anything yet. And let me explain. When a unit owner wants to sell their house, the buyer wants to make sure that the seller doesn't owe any money to the association.
Right.
Because if they buy it with money being owed, now they owe the money, right? So what does the buyer do? The buyer wants to get an estoppel letter from the association, and it's the seller who normally pays for it. So again, that's called an estoppel letter or estoppel certificate.
Yeah.
And the question is, who's going to wind up paying for it? But you want to get it as the buyer so that you could sleep well.
Of course.
Knowing that you bought something with up-to-date assessments.
You have assumption of risk otherwise, and, who does pay this estoppel letter? You're saying usually it's the seller.
Typically it's the seller.
And how much does it cost?
Okay, so lot to talk about here. And let me tell you what it must contain, because it's important that people know this. It not only states how much is owed, because everybody thinks that's it. It just has to say how much is owed on the unit. It's actually a lot more than that.
Like liens?
If there's any
lawsuits?
Assessments coming up, what the association's involved in, all types of things. It's very lengthy letter. It's not just a one-page or one-sentence thing that says the amount owed on this unit is this.
I see. It breaks it down.
It's paragraphs of stuff that you actually have to provide. Even tells you what's a parking space that comes with the unit, who the attorney is for the association, if there's any special assessments on the way, right?
Oh, wow, that's
any
good.
open violations on the unit, and if there's any rules regarding the transfer or sale of units, right? So there's a lot that goes in there.
Yeah, very much.
To answer your question about who can charge what, it isn't easy. It's not an easy question to answer. So here's what the law currently says, all right? An association or its authorized agent, what does that mean? An authorized agent can be the attorney. Authorized agent can be the management company, right? So an association or their manager or the attorney can charge a reasonable fee for the preparation and delivery of an estoppel certificate, and it can't exceed $250 if on the date their certificate is issued, no delinquent amounts are owed to the association. However, if an estoppel certificate is requested on an expedited basis and delivered within 3 days, the association can charge another $100.
Oh, boy.
If a delinquent amount is owed to the association, if an additional amount is owed for a fee of $150, if any amount is owed. So you're talking about, if you add it up,
$500.
You do the math right.
Yeah.
It actually comes out to $500.
So that's how much it would cost to prepare it.
If those things fall into place. So it could be anywhere from between $250 to $500. It gets to $500 if there's anything actually owed on the unit, and oftentimes there is.
And the seller pays that.
And the seller is the one that's paying.
Is there a law that says the seller?
No, normally it's done by contract. The real estate contract says it.
Okay.
Now, the real truth of the estoppel matter is that management firms and law firms say, ka-ching, right? The second that they're asked to prepare an estoppel certificate, because the truth is it's quick and easy money.
Of course it is. So, it sounds unfair a little bit, if it does. Yeah. To you, it does to me. It sounds unfair to Florida Senator Jonathan Martin as well, and Representative Persons Malika. Each of them have now filed bills which would preclude associations from charging for estoppel letters whatsoever.
Yeah. Mm-hmm. Nothing, zero.
Well, that information should be available online anyway, right?
Some of it, yes. Yeah.
So the Senate bill is number 278, and it has resulted in a massive pushback from management companies and law firms alike, each of whom are the ones that normally get paid to prepare these estoppel certificates.
Right. They're not happy about Bill 278, right? It's going to take away a lot of money from management companies, potentially.
Sure.
Well, it depends how you look at it. Is management companies simply going to say, okay, we can't charge the seller of the unit, we're just going to dump that cost onto the association.
Oh, the
association. Charge the association. So here are the arguments. So on the one hand, you got attorneys and management companies say that they deserve to get paid for preparing this estoppel certificate because there's a lot of questions to answer, and there's potential liability if they get it wrong. Right? If I prepare an estoppel certificate and I make a mistake and say, no, there's nothing owed on the unit, and it turns out there's $10,000 owed on the unit, and Eric just wrote a letter that there's nothing owed, that $10,000's on me. Right? So there's potentially a lot of liability there. And, they take the position that only the seller of a home should pay for the estoppel certificate because only the seller needs it, right? And if you're going to prevent me from charging the seller for that estoppel certificate, I'm simply going to pass the cost on to the association as a general bill. So everybody in the building is going to pay for it. And is that fair to everybody in the building to pay for a estoppel certificate because you want to sell your unit? I'm not selling my unit. Why should I have to pay for your estoppel certificate?
But why would there be a bill in some sort of state government that would preclude an attorney from being able to garner fees for something they're doing?
The question is not should the association be able to garner the fees. The question is, should a seller of a unit, right, be hit with a $500 fee for simply telling their buyer how much is owed, right? That's a lot of freaking money to take from a seller.
So you can still bill it.
Right.
But it's that $500.
If you're going to tell me I can't bill the seller for it,
right.
Eric, you can't bill that seller. Manager company, you can't bill the seller that $500. That's ridiculous. That's absurd. It's too much money. The truth is, what are attorneys and management companies going to do? They're going to say, okay, I won't bill the seller, but I'm going to send a bill now to the association, a general bill. I want my $500.
But that $500 is yours, or is yours is above and beyond?
That $500 goes to the preparer of the estoppel certificate,
That's
which
why
is
I'm
going to be
asking,
the attorney.
how can they say you can't bill for your services?
They're saying you can bill it, right? But they want a limit on it, right? A cap on it, and again, for the reasons that it's unfair to a seller. Right, it's too much money to charge a seller $500 because he wants to sell their unit. And why should they get hit with a $500 fee simply to tell their new buyer, "Oh no, nothing's owed"?
It's like a hot potato. No one wants to pay.
Right, or $350 to tell the purchaser that nothing's owed. Isn't that a lot of money? Where the argument is, this is information.
Yes,
it should be readily available. You said it should probably be on the website.
Okay,
right?
So on the other hand, there's an argument that management companies have already paid to keep the ledgers of every owner,
right.
And it shouldn't take more than a few minutes to let someone know what a unit owner owes.
Right,
therefore, they shouldn't receive an extra penny for preparing an estoppel certificate. But you still have the onus of it if it's wrong.
Correct. Right.
On you.
Right. Correct.
So you need insurance.
That's the argument, right? The people that don't want to pay for an estoppel certificate. Wait a minute, you should have this information at your fingertips, management company. All you should do is be able to go to their ledger, print it out. What's the big deal? But attorneys are saying, wait a minute, and management companies say, it's not just telling you what you owe. There's a lot more that goes into it to prepare it. And if we're wrong, we get stuck paying the bill. So, bottom line is, which side is right? Well, here's an update to the bill that's been filed. The bill has now been amended, and it seems that a compromise was actually reached. And instead of now not being able to charge anything like the bill originally came out as, or being able to, you can't charge up to $500, now the attorney or management company can charge up to $250.
Is that fair?
That's the math.
I have no frame of reference.
Probably a very reasonable compromise.
Okay. All right.
That's the idea. It doesn't. I don't think it took a brain surgeon to figure out that a 250 was probably between 0 and 500.
Let's go half.
250 is the mark, right?
I mean, so it certainly seems as if management companies they're pretty big, and they probably have a very powerful lobby in the Florida legislature.
Very, very powerful lobby. They're definitely a force to be reckoned with, and there was no way that this bill was going to pass with management companies no longer having the right to charge anything for an estoppel fee. That was never going to happen. On the other hand, however, someone's selling a unit, maybe they shouldn't be charged $500 for a law firm or management company telling that new buyer that the unit is paid in full or, owes no money to the association. So there was the fight.